If you feel that a doctor caused you significant harm and injury, can you go to an attorney and the following day start a lawsuit against your doctor? You want to know the answer? Come join me for a walk through the neighborhood as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. In New York, the answer is no. And you might be saying, wait a second. If I was involved in a car accident, I could go to an attorney and, assuming the facts were in my favor, I could go ahead and start a lawsuit the same day or the following day after I have all the details and all the information, go to a lawyer and he can start the lawsuit right then and there. That is true. In a car accident case, you could start a case the following day. However, in a case against a physician or a hospital for medical malpractice, the answer is no, you could not do the same thing. Let me tell you why. In New York, we are required to have a medical expert confirm that you have a valid case before we are permitted to actually go ahead and start a lawsuit on your behalf. So let me share with you how you do that. You find the best attorney you can, somebody who's very experienced, who has understanding, who knows exactly what you went through. Now, the attorney has to go ahead and do a thorough, detailed investigation. And what does that involve? A detailed investigation means sitting down with you and for an hour, 2 hours, and getting every single detail of every single event leading up to the wrongdoing, including the wrongdoing, as well as learning about your problems, your physical disabilities, your limitations, things that you can no longer do. All right, so what happens then? What happens then is that your attorney then has to go ahead and now confirm all of the problems that you are having and confirm that your doctor was careless and caused you significant harm and injury. So how does he do that? He does that by obtaining all of your medical records. And when I say all of your medical records, I mean all of your medical records. Not just portions of it, not just parts that you were given when you were discharged from the hospital. I'm talking about the full hospital record. And you might have been in the hospital for 2 or 3 weeks. Your record might be thousands and thousands of pages. Your attorney has to get all of that. Why? Because he has to go through each and every page of those records. He will have to get medical records from the past, from other people you have treated with. Why? To understand what issues you've had in the past, to understand what your medical condition is. So now, once your attorney has gone ahead and obtained all of your medical records, now he actually has to go through all of your medical records. He has to read them, each and every page, to understand what happened. Is that enough? No, that's not enough. There's so much more. Okay, what has to happen next? Once your attorney has obtained all of your records and gone through all of your records, now he has to find a qualified medical expert who is willing to review all those same records and then give him an opinion about the care and treatment that you received. The doctor who he selects, hopefully, is a board-certified medical expert who now can go ahead and read all of the records and then give you an unbiased opinion about exactly what he thinks. The whole point is not to find somebody who's totally in favor of you each and every time. That is not the goal of an attorney getting an expert. Why? Because that does you no service. It does you no good. If this guy is just a rubber stamp, yes, 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 you've got a case, you've got a case, you've got a case, that's no good. I'll tell you why. Because his opinions will be tested during the course of your lawsuit. His opinions and his comments will be tested during the course of your case because we have to itemize in detail and provide to the attorneys who represent the doctors whom you have sued exactly what we believe was done wrong, how the standard of care was violated. We have to show the other side, the opposing attorney, exactly what problems you have because of what was done wrong. And we have to explain in detail that had the appropriate treatment been rendered to begin with, you would not have suffered the permanent, long-lasting, disabling injuries that you currently have now. Also, at the end of your case, before your case ever gets to trial, the expert's opinions will likely be tested once again. Now, what do I mean? When you have gone through the entire litigation process, known as discovery, at some point, your attorney will tell the court, okay, judge, we have now finished all the discovery in this case. We are now ready for trial. And now at that point, the judge is going to give the defense an opportunity to go ahead and try and get your case thrown out. That's known as a motion for summary judgment. And in that instance, the defense is going to bring in medical experts on paper, prepare papers for the judge to explain why your case has no merit. And in doing that, Now we have an obligation to oppose and rebut the claims being made by the defense's medical expert. If the expert that we have hired, or you have hired, if the expert that your attorney has hired at the very beginning clearly did not understand the details of your case, clearly wasn't paying attention, clearly was doing it just to get a paycheck, guess what? There's a good chance that your case will be dismissed because your attorney and his expert will be unable to sufficiently support, from a medical expert standpoint, the claims that you have made in this case. That is why it is critically important at the very beginning of the case that your attorney find the best expert possible in order to properly evaluate whether or not you have a valid case. So what's the big deal? Can't this happen in a few days then? The answer is no, because it will take many weeks, if not months, to obtain all of your medical records. Once those records are obtained, it takes time to go ahead and review them and analyze them. Then it takes time to find the right qualified expert to review your case. And then, of course, it takes time for the medical expert that we have selected to then go ahead and review those records. This could take many, many months. It is only after we have confirmation by a medical expert who has determined, yes, your doctor violated the basic standards of medical care, and that as a result of those violations, those departures from the standard of care, yes, you suffered significant harm and injury. Only then are we permitted to go ahead and file a lawsuit on your behalf. So don't think for a second that just because you believe that a doctor was careless and caused you harm, that you can go to an attorney and that day or the next day or a day after, he'll be able to go ahead and start a lawsuit right away. That's not how it works. Not in New York. That's not what happens. So instead, a thorough, detailed investigation has to be done, and it is only after your lawyer gets confirmation that things were done wrong and they were improper, and had they been done correctly, you would not have suffered these injuries. Only then are we permitted to go ahead and start the case. And you should know something else. When your attorney now gets that confirmation and starts the lawsuit process, we do that by preparing a document called a complaint. And those are allegations against the various doctors and hospitals whom we believe, and you believe, caused you harm and injury. The lawyer who represents you is required to prepare a document certifying that he or she has gone ahead and consulted with a physician who's licensed to practice medicine in the state of New York, who confirms that we have a valid basis for a case. So why do I share this quick information with you? I share it with you to give you a real understanding and to open your eyes into what actually goes into these particular medical malpractice cases in New York. You know, I realize you're likely watching this video because you wanted to see the nice scenery on the walk through the neighborhood. No. I realize you're watching this because you likely have questions or concerns about your own matter. Well, if your matter did happen in New York and you have not yet started a lawsuit, but are thinking of doing so, and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207, or by email at Gerry, Gerry, at Oginski-law.com. Well, that's it for today's video. I'm Gerry Oginski. Have a wonderful day.